Okay, dear audience, welcome to today's workshop on artificial intelligence and intellectual property law. And we already passed the first proof of concept because the network hasn't broken down under the first wave of people logging in. That's very good. This workshop is, as most of you already know, hosted by CIPCO, the Center for Intellectual Property and Competition Law at Zurich University, in cooperation with the Swiss Intellectual Property Institute, IPI. And we are very grateful for the support by the Swiss IP Authority. As you may have gathered from the program on the CIPCO website, today's event is the third part in a research project on AI and IP and a corresponding workshop series. A final on-site conference on the topic with the Intellectual Property Office will be held in summer 2022. At this occasion, we are going to review what we have learned from the online workshops, and we will consider policy, administrative and legislative steps going forward. With this, I already give the word to Felix Ador, Deputy Director General and General Counsel of the IPI, for a word of introduction, after which I will, before our speakers start, make some housekeeping remarks. But now the word is yours, Felix, please.
Thank you, Peter. I don't know whether you want to do the housekeeping before, because as I will already enter the substance, we will be in the middle of everything, but it's up to you.
I can also do the brief housekeeping now, if you prefer, that's fine. So we will, as to agenda, we will hear from you, then from the IP office representatives. Then we will have a first round of discussion co-chaired by Ana Córdoba from the Swiss IPI. After that, we'll have a very short break, something like 5 minutes or so. And then we'll have presentations by our two academic experts, followed by another Q&A session. Hence, there is much room for interventions from the audience, and we invite you to participate very actively. Best would be probably if you flag your questions in the Zoom chat, and I'll then give the word to you. For very urgent questions, we can do that right after the presentations, but generally the idea is that we discuss after each block of presentations. If your mic is not working or you're encountering other technical problems, I can also read out your questions to the speakers, but this should really only be a fallback option. Please also understand that my presentations of the respective speaker will be a very short one. We are now all used to Googling and linking, or whatever you may call that, and you have the profiles and affiliations and everything on the speakers on the website. So with this, I hope I was really short on the housekeeping, Felix, and with this, the work goes back to you.
Thank you very much. Thank you very much, Peter. It's also my pleasure to welcome you from my side to today's third online workshop on AI and IP. Thank you all for being here. I hope you all are safe and well. I would first like to look back, then look a bit at Switzerland's positions and interests in the whole discussion of today, and then have a brief outlook in my introductory words. So the two initial questions with which we started our workshop series about half a year ago were: first, does AI have the potential to transform the IP system fundamentally? And second, if so, what does this mean for all the different stakeholders involved? Did we find answers to these questions? Let's look at it together with a brief reminder of the results out of our first two workshops. So the first workshop took place in June 2021. It provided an overview of the debates and challenges related to IP law and its application to technical and commercial developments in AI. And in September 2021, we held the second workshop entitled Technical and Economic Background. It gave participants a better understanding of what AI technologies offer today and what they will offer in the future. The discussion then turned to international trends in patent protection for AI and new business models for our digital and connected world. If any of you missed any of these two workshops, you find the podcasts on the SIPCO website as well as on YouTube. In these two workshops, we learned that AI has indeed the potential to transform the IP system fundamentally, not only, but mainly for the following three reasons. First, the importance and value of data has completely skyrocketed. Therefore, we have to find a new balance in terms of protection and access to this intangible asset. Moreover, this paradigm shift has, or at least will, completely change the business model of companies. We therefore need to reassess whether IP law still provides adequate protection for each type of intangible asset. Second, AI is not only changing the way humans create and invent, but it is also offering, or will soon offer, its own new way of autonomously creating and inventing. This means that fundamental concepts of IP need to be re-evaluated to ensure that they are still relevant. We also need to decide whether and how to give protection to future autonomous productions. And finally, the whole creative value chain is changing. It has traditionally been the role of IP to reward that creative effort. We also need to re-interrogate that value chain and to decide what kind of effort and intensity of effort we want to reward and how we want to reward that effort in future. In consequence, the short answer to the first introductory question, does artificial intelligence have the potential to transform the IP system fundamentally, is a clear yes. The IP world will change due to AI. So let us now turn to the second introductory question, which is what does it mean for the IP system and all its stakeholders that AI will transform the IP system fundamentally? Actually, this is the topic of today's session. As the co-host of the workshop series on AI and IP, please allow me to share a few thoughts on the subjects of today. At the first workshop, I announced that the Swiss Federal Institute of Intellectual Property's ambition in launching this workshop series is to listen to expert thoughts and experiences and to discuss them with you, our audience. Nevertheless, after the second workshop and the preparation for today, we have raised our ambitions. We want to use the momentum of this series of workshops to prepare the achievement of tangible results. For this purpose, we want to learn from our colleagues from other IP offices who are pioneers in this field. Therefore, I'm pleased to welcome them today. Beyond their valuable and much appreciated participation in this workshop, we are interested to work closely with them on this topic since our offices are linked by agreements allowing for closer collaboration on this issue in future. Let me briefly share here some of our first ideas and our plans on some of the issues at stake today. On the national level, the Swiss Federal Institute of Intellectual Property is planning a data, AI, and IP strategy to ensure that Swiss intellectual property law remains beneficial to innovation and society generally. In saying this, I must immediately make it clear that the IPI has not been sitting idly by at the national level so far. To benefit from the new opportunities of digitalization and strengthen Switzerland as a location for research, an exception for scientific purposes, comparable to a text and data mining exemption, has been included in the new revised Swiss Copyright Act. This entered into force in April 2020, and Sabrina Conrad from our copyright team will give you a short overview on this afternoon. On behalf of the Swiss federal government, the IPI is also active in non-personal data sharing in the private sector. In this regard, we first mapped the Swiss legal framework for non-personal data, and then we assessed the need and value of different potential legislative interventions, such as the introduction of ownership of non-personal data, compulsory licensing, or FRAND licensing schemes for non-personal data. To cut a long story short, we ruled out all these ideas. So we don't think that we need any adaptation of our legal framework with regards to non-personal data. We also measured the current economic weight of non-personal data in the Swiss economy and compared it to the results of our neighbors. Switzerland performs relatively well in this area. We expect a strong growth of non-personal data activities in the coming years. In order to support this trend and to improve the framework conditions in Switzerland, we have developed a series of model contracts. We will soon discuss them with the Swiss business community in order to establish best practices for accessing and sharing non-personal data. Last but not least, we plan to establish a resource center on this subject, modeled on the European Union's online resource center. At the international level, Switzerland works in various ways, especially in international fora such as WIPO or the EPO, both present today. Switzerland is a small open economy. Our unique selling proposition is innovation, being for more than 10 years on the top of the Global Innovation Index. That's why we are interested in a functioning multilateral IP system. Our most important goal is to realize comprehensive and internationally harmonized solutions for common problems. This is the reason why we want to be active in the international discussions in a concrete and result-oriented manner. We want to act both as initiators of discussions and as bridge builders, especially in the European Patent Organization and in the World Intellectual Property Organization. In my view, WIPO should lead the international community of states quickly to harmonized general solutions to the problems at the interface of AI and IP. Such solutions should be further substantiated and specified by regional organizations such as the EPO, and after that sensibly implemented and enforced by the individual member states. However, if WIPO or its member states do not succeed in presenting a convincing roadmap in the foreseeable future with a view to elaborate and implement tangible solutions, I fear that we will very soon see many well-intentioned but uncoordinated national solutions. This would lead to a fragmentation of the law, which creates problems for those seeking clarity and is associated with corresponding uncertainties and costs. Long story short, the IPI wants as soon as possible a comprehensive and harmonized solution for all IP and AI issues that is pragmatic and supportive of research, innovation, and society. I know this objective is clear, very simple to express, but I also know that it is very complex to achieve. With this, I'm coming to my last point, an outlook. This year is still young. If we look a bit into the near future, we see that in 2022, WIPO will continue the WIPO conversation on IP and AI, led by Ulrike Till, our first speaker. And the WIPO Standing Committee on the Law of Patents will deal with this topic too. Discussions on the use of AI for the examination of patent applications and other activities of the IP offices will intensify. Switzerland would like, therefore, to focus the discussions on collaboration between offices and better access to tools already developed by IP offices. The question of the patentability of inventions generated autonomously by an AI system will also continue to be discussed. This, of course, is where both philosophical and technical discussions on the designation of the inventor and the ownership of such inventions will take place. Please allow me to share with you a few thoughts in this respect. Regarding the designation of the inventor, we think that between, on the one side, admitting an AI system as the sole designated inventor of a patent application, and on the other side, dogmatically just refusing to consider the possibility of a patentable invention without an individual human inventor, there is a whole gradation of solutions which should be seriously considered. Let us remember that historically, in many legal systems, patent law existed for a time without any requirement to name the inventor or without strict enforcement of this requirement. Moreover, there are still a very few, but some countries that do not require the designation of the inventor. We also should not forget that the current system allows an inventor to remain anonymous to the public. The problem of so-called company inventions is also well known, especially in the pharmaceutical field. These inventions are intrinsically linked to the company's internal knowledge. Hundreds of people are involved in the work that finally can lead to an invention without one being able to say that he or she individually contributed significantly to the invention. That's why at the Swiss Federal Institute of Intellectual Property, we have a lot of sympathy for a solution that would make the designation of the inventor more flexible. If the applicant considers that no human inventor can be identified, the inventor's designation should, in our view, remain blank, without this leading to the rejection of the patent application. We tend to think that the requirement of the designation of inventor should not make applicants lie or renounce patent protection for their invention. We consider it important that solution-oriented proposals will be analyzed already this year in the appropriate international fora. Of course, the topic of AI goes beyond the strict framework of IP. In 2022, there will also be intense work on AI in the Council of Europe, the European Commission, the European Parliament, in UNESCO, the OECD, the WTO, and the International Transport Union. In each case, the IPI will be involved from the perspective of data, AI, and IP to ensure a harmonized and coherent worldwide solution. Obviously, AI is transforming the IP system and much else besides, and it is not yet entirely clear where this development is taking us. For this reason, the team of Peter Picht and my team have initiated this workshop series in order to bring an interdisciplinary group of specialists together to discuss possible ways forward from their various points of view. Before giving the floor back to you, Peter, I want to thank you and all your colleagues for organizing these workshops and all the speakers who will present their work and ideas today. I look forward to an interesting workshop. Peter, the floor is yours again.
Thanks so much, Felix, for this comprehensive yet concise, as it were, look back and look ahead. I think this was an excellent introduction, not only to this workshop, but also to this entire year 2022, a year momentous for AI and IP globally, but also for Switzerland, as we've heard from you. You also did the nice job of practically already introducing our first speaker, which permits me to give right away the word to Ulrike Thiel, who is the Director of the Intellectual Property and Frontier Technologies Division at the World Intellectual Property Organization, WIPO, and arguably WIPO's leading mastermind on AI and IP policy questions. Also, because, and Felix has already mentioned this, she's a driving force behind the WIPO conversation on AI and IP, which many of you are probably following. Fabulous that you are here, Ulrike, and start off our agency panel today, and the floor is yours.
Thank you, Peter. Thank you, Felix. With those introductions, I feel I could almost be going home. There's much already be said, and I think you set the goal quite high. I have a small presentation. Let me just try and share the screen and see if I can get on with that, and then we can kick off. Has that arrived? Very good. It's good to see. Well, it's a pleasure to be here. Thank you so much for inviting me. Thank you so much for having me. As Peter said, I am Ulrike Thiel. I'm not sure I'm a mastermind, but I'm certainly the director of the IP and Frontiers Technology Division at WIPO. And in that role, I have the real privilege of being at the center and the heart of the debate on AI and IP. AI certainly is currently one of the hottest topics in IP, and it raises a myriad of questions, both for policy and for legal design and for the IP system. And really those two fall into two buckets. One of them is how AI fits into the existing IP legal framework, but not to also forget what AI can do for the existing IP framework. The questions and the debate around AI and IP, as I said, are multifaceted. And I know we have many other speakers who are much more experts than I am and better masterminds than I am, who will talk you through some of the details. And I believe you'll hear about patents, about inventorship, about Davos, about copyright exceptions, and also on some of the tools and some of the uses that IP offices are putting AI technologies to. Given that breadth and complexity of these issues, and given my role as part of the WIPO conversation to try and have a global overview, what I thought I would do is set the wider scene for you. And that is really to provide you with an overall landscape of the issues, also the issues that we've been raising in the WIPO conversation, that will make it easier for you to gain an overview where all of these different jigsaw pieces fit in, and hopefully to come away to have a much more holistic global overview of the different facets of the debate that we're seeing. I will also spend a little bit of time talking you through what we're currently doing at WIPO, and most importantly, how you can get involved in those conversations, because I think having those conversations and having as many people join us in those conversations, have their views heard and shape opinions, is going to be absolutely key. So I will start very, very briefly with just setting a scene, and that is we're all aware we live in an unprecedented era of interconnectivity. The sign that we're having this workshop on Zoom in the middle of a pandemic is only one glimpse of the amazing transformation that our lives are undergoing on a daily basis. And really driving this transformation are what I personally call frontier technologies. I know it's a little bit of a sci-fi term, but I think it's quite a cool name for a division to have, IP in frontier technologies. And when I say frontier technologies, really what I mean is technologies that operate at the intersection of breakthrough science and practical implementations. And really, AI is absolutely key and central to these shifting dynamics. But I put frontier technologies here because I think it's also going to be key to remember that frontier AI is only one of these frontier technologies. There are others such as the Internet of Things, robotics, blockchain, the human brain interface, and these all come together and they really change how we innovate, how we create, and how we do business around the world. And one of the themes that I was going to paint for you, I'm trying to paint for you in my short presentation, is to have that global overview of AI is certainly a key topic, but see the wider context of the transformation that we're going through is going to be key to design the appropriate systems. AI is certainly the most prolific, as I said, of the new technologies, and that is in terms of the number of patent applications and granted patents that we're seeing. If you haven't seen it, it's a couple of years old now, but the WIPO Technologies Trends Report 2019 makes some fascinating reading in that regard and seeing the speed up of IP patent applications and patents in the AI fields. And clearly that rise of AI patents and applications in itself has an impact on the work of IP offices around the world. However, also again, going back to context, I think it is worthwhile to remember that in terms of market size, the Internet of Things is by far the biggest one of the frontier technologies at the moment. And again, by market size, that's followed by big data. So data is going to be key also for AI, a topic to look at, and robotics. Then comes AI, and that is followed by 3D printing and 5G services. Overall, there was a study that came out last year. Currently, it's estimated that the global market for frontier technologies represents about currently US $350 billion. And that is predicted to grow to 3.2 trillion by 2025, with the AI market by that time to be around US $300 billion. So it's a massive economic growth and potential that we're looking at, which is why it's so key to have a look at these issues. Unsurprisingly, and this is why we're all here, IP is rapidly gaining increasing importance over physical assets in our digital world. Innovation, creation, and IP, I think we all agree, go hand in hand, and IP is going to be central to drive this economic growth and potential of frontier technologies. However, the IP system that we have today was developed with a focus of human creation and innovation, and certainly to encourage the development of technologies that enable production and trade of physical goods, not the digital world. The IP system that we currently have today was also designed when the speed of innovation and creation was significantly slower than it is right now. So from my perspective and a WIPO perspective, one of the most important tasks that we face is to ensure that the current IP systems continue to promote innovation in the digital age. And really what we need to ask is twofold. It is to say, how do these new technologies, how does AI fit into the current IP system? And not to forget about what can AI and the new technologies do for us to make these systems faster, cheaper, more accessible, better, to make everyone benefit from IP everywhere. I will whiz through the next one because I think Felix has said it much more elegantly than I possibly could. I entitled the slide, "What's the fuss all about? Why do we see this buzz of conversations, of workshop? Why in the IP field is everyone talking about AI?" And really the heart of the matter is that the systems that we have were designed to foster human creation and innovation. And that is the crux and the heart of the debate. And I think also that is why in many ways the Davos cases that no doubt everyone on this call in this workshop has talked about and is talking about are so key and so much in the center of attention, because in some ways they were specifically constructed to highlight why AI raises some fundamental questions to the existing system. AI is not a new technology. It's over 60 years old by now, but really it's advances in computing power and AI models, and in particular data and the availability of training data that is driving AI and the current AI boom. So data, as a placeholder, and some of the things I'm going to say in a little bit, is going to be key when we're looking about AI and IP. Most of the current AI applications that we're seeing at the moment can be described as what I call narrow AI. There clearly is a very lively debate whether, and if so when, general AI might become available. I think taking a step back, what is becoming abundantly clear is that AI is increasingly becoming more autonomous, and that the required human input is decreasing or at least changing. So while we may or may not have reached a position where AI can invent autonomously, so what Davos is arguing in very many ways, I think there are many and a myriad of current questions for inventors and creators today that are being raised by AI. And really the crux, going back to the heart of it all, is the system was designed with human-centric in mind. And it raises the question is, how does AI innovation and creation fit into the current system? Should IP apply at all? Does AI innovation creation need IP to be incentivized? And at the end of the day, how do we balance the value of human innovation and creation versus AI innovation and creation? And I like to, that sounds very theoretical, but just to give a quick example, AI-generated music is already increasingly being used in advertising and is being used in movie soundtracks. At the same time, AI is also being used as a tool by musicians around the world in music creation in collaboration with humans, with human input by human producers and musicians. So at the one hand, there certainly is the ability to create large amounts of music pieces at the press of a button, zero marginal cost. At the other hand, it's a tool that is used by human creators. So really, how do you treat those pieces of music? Should they be the same for copyright? Should you draw a line, and where should that line be? And that is really what is at the heart of the matter. Everything's connected. This is a point that I find key in the whole debate, and that is sometimes we hear reference to AI being just another technology like photography to which the current IP system will adjust. And that is certainly one side of the argument. I will give you the other side of the argument, and that is, unlike photography, AI really implicates every IP right and every part of the IP system. And really some of the other speakers, I hope, will give you a deep dive in some of the facets of the debate. AI is being used in the inventive process, for example, in drug discovery or to identify drug candidates. And that raises questions potentially for concepts of inventiveness and obviousness. AI can also be part of an invention, for example, as part of a diagnostic tool. And that might raise questions of sufficiency of disclosure and of training data. AI also has many contributors, data collectors, algorithm developers, the people that operate AI and more, which really raise complex questions of what we mean by an inventive contribution under patent law. And again, I think you'll have a deep dive into that by others. If you are shopping on Amazon or watching movies on Netflix like I do during COVID, then certainly AI will be implicated in the selection of your choices, and there are questions of trademark law and human perception in that regard. We talked about copyright and about AI copyright for AI-generated works, but there are also clearly questions how copyright interacts with the use of works in AI data training sets. And again, I believe from what I've heard from Felix and Peter, you will have a deep dive in some of that. Overall, WIPO put together a list of all potential questions we could think of for the IP system, and comes with a warning. It's called the so-called WIPO Revised Issues paper, and it runs into 7 pages of really dense reading, and that's the breadth of the issues. So from my side, one of the biggest takeaways is to remember the overall picture, and that's not a single IP right. We're really looking at the entire scope of the IP system. What's more, it's complicated. It's not just IP. AI raises many questions across a multitude of topics, from ethics to security, privacy, competition law, and more. And really, another takeaway from my side is that IP policy needs to be cognizant of these different streams of discussion. So from my side, a takeaway is not to forget the bigger picture. Where does IP fit into the overall regulatory matrix for AI? And I know I'm an IP geek by heart. I've done IP my entire life, my entire career. It's super easy to get sucked into the depths of the IP debate, or within the IP debate into a very narrow issue. From my side, it's a plea to every solvent to surface for a breath of air and see where it fits all in the overall system, where we're trying to go. A word about data, because it's a little hobby horse of mine. Data in many ways is an illustration of all of the issues about AI and IP that I talked about. And it's also a field that is attracting more and more attention from regulators worldwide. And I'm very glad that Felix started on the data topic in his introduction. Data is a key ingredient for AI. Without data, let's be clear, there would be no AI. Data is also, in some ways, a fairly new beast in the IP field, but really how we deal with rights and data and IP rights and data will very much shape the future of AI. I think it's key to understand the nature of data, and it's key to understand the value of data when setting out to find a regulatory matrix for data. And it's a very diverse set of information with very different characteristics. This is just a whistle-stop tour. It's incredibly difficult to define what we mean by data, but it's very clear that it can be incredibly valuable, although we find it very hard to define the value and calculate the value sometimes. It's clearly available in vast quantities, often at marginal cost. Yet not to forget, sometimes some raw data, such as satellite data, remote Earth sensing data, or clinical trials data, can be vastly expensive to generate. Data is often meaningless, and much of the value is being derived when it's analyzed or understood in context to form insights. Yet on the other hand, very often it's the cleaning up of the data, the preparing of the raw data ready for analysis that gives the biggest investment cost, not the analysis itself. And despite this investment cost, data is a non-rival good that increases in value as it's being shared. And talking about the complex matrix, often we think straight away of data privacy and GDPR-like provisions when we talk about data. Yet the regulatory matrix is much more complicated: security, competition law, cultural approaches, and of course, IP. And that brings me back to the topic of IP, data and AI. Regulation generally tries to aim at establishing a balance between protecting rights and investment in data on one hand, and encouraging the free flow of data on the other. And really, in this complicated system, the interface of data and IP matter, and it matters greatly, because at the one hand, IP can pose an incentive for the generation of data, for example, by way of trade secrets or database rights. Yet on the other hand, IP can certainly provide a hindrance to the access, analysis, and use of data, for example, when data contains copyright-protected works. From an IP policy perspective, it may be worthwhile taking a step back and asking really whether data needs IP incentives at all and what that incentive should be. So another takeaway from my side is, when we talk about AI and IP, let's not forget how data fits into the overall system. And that brings me very much to the end of my whistle-stop tour in opening the topic in the workshop for everyone. In the area of frontier technologies, WIPO's work and mandate has a couple of strands to it. The first is certainly raising awareness of the new technologies, very much AI and their IP implications. and providing a global leading forum for a balanced policy discussion. And that forum is the WIPO conversation, which is quite a new format to WIPO, and it's open to everyone that wants to join. And the more opinion, the more information sharing we have, the better the conversation will be. On average, and this is something that I'm personally incredibly thrilled by, and in some ways overwhelmed to see the interest. On average, we have about 2,000 people from 130 countries joining us. It also gives you really a key indicator of the passion people have and the importance of the debate. The conversation started in 2019 to raise awareness, certainly on AI and IP. The second and the third session of the conversation took a real deep dive into that. And maybe unsurprisingly of what I said in my little detour via data and IP, the fourth session honed in on data and its importance for the AI and IP field. Again, the news has already been taken away from me. Hot off the press, we have announced that we will be continuing the WIPO conversation, not just this year, but going forward in about 2 to 3 sessions a year. For anyone that has their diaries and pens ready, session 5 will be April 5 and April 6, and session 6 will be September 21, 22. And I'm very glad we're having this debate today, because the next session in April will very much be focusing on what AI and other frontier technologies can do for IP administration, on AI tools and what it all means for our IP systems. And later in the year, we'll come back to, I think, a very keen topic people are keen about AI inventions. And this is my little marketing exercise of saying, come and join us, please, because we really do get better and we rely on your expertise and your opinion. I was going to finish to say a second strand to what we do, as well as the policy discussions, and as important or even more important, the second main part of our engagement is to continuously update our services to take advantage of the new technologies and to also assist IP offices around the world to do that. There are really important questions what AI can do to enhance the current IP system, to make IP more accessible, relatable, faster, efficient, and really benefit everyone everywhere. And that is so key, because IP is becoming increasingly important, and we need to make sure what we can do to see our systems are ready to keep up with the innovations of the future, and they're ready for the futures. Great examples of AI tools developed by WIPO include things like WIPO speech to text, WIPO translate, WIPO brand image cert, and patent classification tools that are all based on machine learning. And really, these, I think, are going to be key for the IP offices of the future that are ready to protect the inventions of the future. That was a total whistle-stop tour. I hope I haven't overstayed my time of the 15 minutes that I promised Peter would take. My apologies if it was a little longer, but it is a vast topic to cover. And really, I'm so keen to hear from the other speakers about the different elements and how it all fits in, and a really good debate. So thank you so much for listening to me. And with that, I would hand over back to Peter for a wonderful day and a wonderful workshop of discussion.
That was great, Ulrike. Thank you so much. Not only in terms of showing us what is going on both around the globe and in WIPO regarding the use of AI, but also in terms of policy questions. And I can well imagine that we take up many things you said just before, also in the last part of this workshop, together with our academic experts, Avi and Gaëtan. So looking ahead to very interesting and fruitful discussions. Before I hand over to our next speaker, I must also say that I feel a little bit proud that we were so topical as to address the use of AI tools by IP offices even before it is the subject of a WIPO AI IP conversation. But of course, you know, we will be listening very keenly to the results of that conversation. With that, I'd like to go on. Our next speaker is Heli Pilayama. She's the Director of Patent Law at the European Patent Office, and thus a core person in shaping the EPO's policy, including on the matter of AI and IP. She will now let us know what these policies are and take us really into the field of patenting with regard to AI technologies. Haley, please instruct us.
Thank you very much. Good afternoon and Happy New Year to everybody. Thank you also for SIPCO and for the Eidgenössische Institute for having invited the EPO and providing us the possibility to speak here. I'm also happy about all the preceding speakers having taken up many of the important points, because that can that allows me then to make some disclaimers. I can get out from presenting statistics, because the growth of innovation in the area of AI is really remarkable, as stated by Ulrike, and also I'm in the happy position, in comparison to the previous speakers, that the European Patent Office is responsible for granting patents and examining patent applications and oppositions, and then we have the Court of Appeals for the appeal procedure. So we are not needing to focus on the other areas of IP as the previous speakers. However, despite that, before I start sharing my screen and sharing my presentation, I would like to very much underline two statements that the previous speakers made. Namely, it is clear that for IP, and especially for the patent system, a global solution for any of the issues arising from AI, and I'm saying AI and patents, patentability is certainly necessary, because this is one of the basic features of the patent system. The second point that I would like to underline is that, as the previous speaker stated, any of these questions we are discussing now, even though at the, when we are at the EPO, are in the lucky position that we are only dealing with patent law as the main business, nothing can be seen in isolation. We have to see the IP system as a legal system, part of the legal systems in the society, and therefore, as on the slides of the previous speakers, it's competition law, it's contract law, it's institutional law, it's the basic questions of rights and obligations, as I will soon also mention in the presentation to come. Now, let's see. I'll start sharing my presentation.
Yep.
It's
there
on.
It is.
I hope that I can, now it's in the. So
Perfect.
to come to the legal aspects of patenting AI-related innovations, and especially the questions of patentability and inventorship. One of the first questions here is that we will hear from the academic experts also this afternoon, is the question, what do we talk about when we talk about AI? How to define AI in the context of the questions we are addressing in patent law? The European Patent Office has taken as a basis a definition that artificial intelligence is a broad subfield of computer science that covers many different computational models for solving data analysis problems. Here on the slide, we have then some further definitions, so I'm not going in this context into showing all the different examples of AI-related innovations, because I understand that in the previous rounds of this discussion, that has also already been done by the experts. For the European Patent Office, the inventions related to artificial intelligence, where we also take machine learning as part of artificial intelligence under the broad definition I showed, or that is on the first bullet point, those fall under the definition of computer implemented inventions. And thus, such inventions are patentable if the general patentability criteria are met. Of course, when we look at categories of artificial intelligence related inventions, we see three different categories at the abstract level. In the previous presentation, there were the definitions of narrow and general AI. For the patenting terms, we are making a difference of human-made inventions, which are using artificial intelligence for the verification of the outcome. Or we are seeing inventions in which a human identifies a problem and uses artificial intelligence to find a solution to the problem. This, of course, is very much linked to the problem solution approach that we apply. And then the third category, which is for us still a question mark, is then the category of AI-made inventions in which artificial intelligence would independently identify a problem and propose a solution without human intervention. When we are looking at this category, we are often having nowadays a discussion that, of course, AI can write a patent application. In this discussion, I'm often then putting the question, is the patent application or the writing of the patent application the invention to be protected? We all know that there are a lot of text processing tools that can copy-paste texts and combine them in a certain format. When we then go to look at the patentability requirements, according to the European Patent Convention, inventions in all fields of technology that are new and inventive can be patented. We have the exclusion of mathematic methods, programs for computers, which are not regarded as inventions if claimed as such in the application. However, according to the established case law and practice, which has been confirmed in the recent, still quite recent decision of the Enlarged Board of Appeal, G119, about simulation methods, we get the teaching that all features, so when there are some technical features, then the threshold, the first hurdle about the not being considered as an invention is overcome. But then for the inventive step assessment, according to the so-called convict approach, only features contributing to the technical character are taken into account for assessment of inventive step of an invention in the field of computer implemented inventions and artificial intelligence. Then, of course, when we look about the technical application, so there needs to be the technical application that is serving a technical purpose, for example, output used for technical purposes or specific technical implementation, for example, mathematics specifically adapted to exploit the hardware or designed based on the technical adaptations or considerations relating to internal functioning of the computer. One of the patentability criteria or the criteria for the patent application is the disclosure of the invention. This has been identified as a further question mark for the AI-related inventions. But here it has been often questioned whether the AI-related inventions can be disclosed sufficiently clearly, also taking into account the potential function of use of data in the invention or the machine learning part there. Here we have already got guidance, clear guidance from the Courts of Appeals, which in 2 specific technical decisions cited here on the slide have made it clear that the same principles apply also for the AI-related patent applications than for any other patent applications. The description must disclose any essential feature for carrying out the invention in sufficient detail to render it apparent to the skilled person how to put the invention into practice. Of course, it might be that depending how the claims are defined and what is claimed, the underlying algorithms and maybe even the corresponding training steps or even the training data would need to be disclosed in the application. The experience with the thousands of patent applications relating to artificial intelligence related inventions shows us, however, that normally the training data itself is not needed in the application. The definition of the training data, as well as the purpose, how to use it, for which purpose and how to use it, would be sufficient. Of course, that is also a part of the processing of the applications because, and also the information content of the patent applications, because huge volumes of training data might not also be useful for the information purpose of patents. The person skilled in the art, here we have quite clear case law about the person skilled in the art, that actually the person skilled in the art used in evaluating both the inventive step and also the disclosure of the sufficient disclosure of the application can be a team. And of course, what is normally required from the person skilled in the art is that the person skilled in the art knows the relevant technical fields. Certainly, it might then also be that the person skilled in the art knows how to apply the AI tools, the AI systems in that field. We have been since 2018 adding in the guidelines for examination at the EPO artificial intelligence related content in the part concerning computer implemented inventions. Our guidelines for examination are actually intended initially as working instructions for the examiners, but they are also serving as information purpose, as information tool for the general public and for the users of the patent system, so that the users of the patent system know what we are, how we are intending to apply the European Patent Convention in the examination of their patent applications. Of course, with that purpose, the guidelines are there also to assist or for assistance to users, for them drafting applications or for arguing their cases. The guidelines are revised annually, and the next version, so the 2022 version of the guidelines, will be pre-published now in a couple of weeks, early February. It will be a pre-edited version, so it's not the final. The final will enter into force 1st of March. All you here today who are interested in AI related patents, I would like to give you the pre-information that there would be also quite some additions in the 2022 guidelines for examination of the EPO. We have also added one more example, a concrete example in the guidelines, and which we hope that this example would then be helpful for any users for drafting their applications. We are continuing with further work on the guidelines and to get the information even more complete and comprehensive. So therefore, as I'm also using here the possibility to promote something, namely that we are conducting a user consultation and would be very happy to get your input about the guidelines, especially on the AI related parts in the spring 2022, because we really would like to focus on that part next year. It was already mentioned by the other speakers, the famous DAPUS cases, the two DAPUS applications filed in 2018 in several jurisdictions. Here, the main drawings and the EP numbers, as well as the titles of the inventions. These applications have caused some discussion because they have pointed to the one important aspect that was in the opening speech today as well, namely the question of inventorship. We have had a lot of discussions in the IP level globally about that question, and also with our contracting states, and we from the European Patent Office are going to continue these discussions intensively into 2022. In the previous discussions, especially with the IP5 offices, there has been the main finding and understanding, a common understanding, that inventor is the person who created the invention by their own creative activity. In many of our contracting states, it is also a requirement in the national laws that the inventor needs to be a human being. So a human being needs to be designated as an inventor. The principles for the European Patent Office and for the European Patent Convention in that context are that the right to the patent, we are talking about rights here, and the right belongs to the inventor. The inventor has the right to be mentioned as an inventor and has right also to waive the right, to waive the possibility to be seen as an inventor. So needs to be designated, but can then say that the designation does not need to be published. And the right to the invention can be transferred according to the principles of national law, contractual law normally that applies there, or employment law, depending on the contracting state. And so in many of our contracting states, there are, for example, the provisions concerning right to the inventions during employment, which are then playing a role there. The national laws, they also cover the questions of legal personality, and the national laws govern the principles who can have rights, or what kind of subject or object of rights is possible. At the end of the day, the questions who is the inventor needs to be decided by national courts. But the requirements for European patent applications are covered by the European Patent Convention. So with these principles, the European Patent Office in 2019, with the decision issued in writing early 2020, refused the applications, the DAPUS applications, which were designating an AI system as inventor. The reasoning, in essence, was that inventor, in the sense of the European Patent Convention, refers to a natural person only, and AI systems have no legal personality. Thus, they cannot even transfer the right to a successor in title, and because they don't have any legal personality, they cannot have a name for the purpose of designating, giving a name in the application. It was stated in the decision of the European Patent Office also that the designation of inventor is a formal requirement, and thus it is independent from the substantive patentability requirements. So whether the invention was novel or inventive, there is no statement on that. You might have been following these DABUS cases where there has been decisions from several patent offices and courts around the globe. And for the European Patent Office on 21st of December, the Legal Board of Appeal confirmed in a final decision that, confirmed the decision taken by the EPO, and in the oral hearings stated explicitly that an inventor needs human quality under Article 60 European Patent Convention. We are still waiting for the decision to be issued in writing with all the details. And of course, that would then lead to further discussions with our contracting states. But that confirmation of the decision of the EPO by the Legal Board of Appeal with the certain statement gives us some guidance for the future regarding the inventor question. Of course, all these discussions with our user community, with our contracting states, with the IP5 are going to be continued with a lot of emphasis on the different open issues concerning, or the different issues to be developed concerning patentability, and to see the adaptability of the patent system for these questions. And we will see what comes then from the other jurisdictions, also especially relating to the DABUS cases. Thank you very much for your attention. I'm happy to answer questions when we come to that part.
Thank you very much, Haley. That was really very interesting. I'm sure we will be discussing DABUS later on. And I was also thrilled, as I think many in the audience were also, to hear about the upcoming revision of the EPO guidelines and your openness to our input regarding AI in that process. So this is really also a very nice coincidence, and I'm sure we will also be able to kind of discuss our views on that and the IPI and EPO positions on that in the on-site workshop in June. So thank you very much for taking us through the patent side, as it were, of AI and IP, and the very, very important voice of the EPO in that respect. With that, I would suggest we now kind of switch a bit away from patents and a bit more towards copyright with our next speaker, who will be Trina Ha. She is the Chief Legal Counsel and Director of the Legal Department at IPOS, the Singapore IP Office. And she is one of the mothers of the 2021 Singapore copyright law reform. And she will now tell us how closely this reform is actually related to today's topic. Thank you for introducing us to the copyright side of AI and IP now. Trina, the floor is yours.
Thank you, Peter. Thanks for that kind introduction. I didn't think of myself as a mother of the copyright bill, but considering it took a few years, maybe that's an apt description. Good afternoon, everyone, and Happy New Year. IPOS is really honored to be invited to take part in this webinar, and we thank IPI and the Center for IP and Competition Law for the kind invitation. I have prepared a presentation, so I hope I'm able to share this. Yes. Okay, so the previous speakers have brought us through very clearly and eloquently on all a comprehensive overview of AI and the issues in relation to IP. what I hope to show today is more of a snapshot of what the IP office is doing in terms of a policy overview, legal reform that we have undertaken or that we are contemplating. And I'm personally more involved in the policy and legal side, but I will touch briefly on the use of AI tools in the IP registry functions. Okay. So in terms of the policy overview, Singapore has a national AI strategy that was published in November 2019, which expressly recognizes the important role of the IP regime in the development and commercialization of IP technologies. As such, we at IPOS actively monitor and try to engage in conversations with other IP officers on the various developments on the AI-IP interface to ensure, as was said earlier by Felix and everybody else, that the IP system should support technological advances and support innovation. To that end, we do participate in the WIPO conversations, and I'm looking forward to the next session in April. We've also embarked on a research collaboration with the Center for AI and Data Governance of the Singapore Management University and the Infocom Media Development Authority. Now, we had contemplated having a call for comments on identified issues, but in the end, we decided with the university's guidance to look more into focus group discussions, supplemented by one-to-one engagements with different groups of key stakeholders in the AI field. So the groups included AI innovators from multinational corporations to local enterprises and even startups, to IP lawyers and policymakers from a diverse range of industries. The purpose of this policy was to actually understand the different perspectives and views for all these, from these different stakeholders as to what they understand about IP, how do they see its applications and the relevancy of the IP system, and whether it supports or even causes obstacles or issues for them. And from there, what we hope to do is identify real on-the-ground issues that these groups, especially the enterprises, are facing, and then perhaps embark on how do we design, with consultation from the stakeholders and industries, the necessary legislative measures or policies or processes to continue to ensure the IP regime supports innovation. We are in the process of reviewing the results, and we hope to be able to present some findings by the second half of this year. Now, talking about legal reform, I'll go straight into it. And as Peter said, I'll be focusing quite a fair bit on copyright. So Singapore embarked on a very extensive review of the copyright legislation a few years ago. We embarked on various consultations, and it culminated in an entire rewrite of the Copyright Act to update copyright for the digital age. And it came into force on 13 September last year. What I will be focusing on today, as relevant to the topic, is a statutory exception for the copying of copyrighted protected works and protected performances, specifically and only for the purpose of computational data analysis. We did not confine it to just text and data mining. We had a broader definition of computational data analysis, and I've actually explained in our statute that this includes sentiment analysis, text and data mining, and training machine learning. The impetus for change to introduce this exception is fairly straightforward. There was no specific exception for data analysis, the use of copyright works in data analysis under the old statute. We did have and still continue to have a US-style fair use exception, statutory 4 factors as well as any other relevant factors. And we understand that there have been successful use of this exception for such activities in the US. However, because the fair use exception is a very factual determination, it can lend a fair bit of uncertainty to researchers and businesses because of the investment needed to venture into this area. And we do want to drive and catalyze data-driven innovation to encourage the use of big data, data analytics, not just for improvement of businesses, but because of the social benefits some of these wide-ranging applications can derive for healthcare, for education. For instance, our Ministry of Education is in the process of finalizing a translation portal that will translate text into our 4 official languages. And the use of machine learning will help improve the quality of the translations. So it was very important to have a targeted specific exception that allows these users, but with inbuilt in it safeguards to also protect the interests of rights holders. This exception was consulted extensively from rights holders to creatives, to intermediaries, to users, both corporate as well as individuals. And it went through not just a policy consultation, but we also had a technical consultation where the draft legislation was put out for 2 months and views were collected. So let me go through what are the key features of this exception. Firstly, as I said, it does expressly recognize the use of computational data analytics for machine learning. Both commercial and non-commercial users are allowed. We do not distinguish. Users must have lawful access to the materials from which copies are made. To be very clear, we actually have illustrations in our act. For instance, you cannot circumvent paywalls to get access to the materials. Now, copying includes storing or retaining the copy. And quite importantly, because of the nature of text and data mining and how it is almost impossible to be able to control the source material, the use and access to the source materials, this exception cannot be overridden by contractual restrictions. So under a new Copyright Act, we do have a list of certain exceptions that cannot be overridden, and this is one of them for computational data analysis. But there are, as I said, limitations and conditions to be fulfilled before this exception can be used. We understand increasingly there is a lot of cross-border, multi-jurisdiction research collaborations. And it is important that you allow the sharing of the works with others, but we have restricted it only for verifying the results of the computational data analysis or for collaborative research or study relating to the purpose of such analysis. As I said, lawful access to the works to be copied is a requirement, and the work from which the copies are made must not in itself be an infringing copy, unless, of course, you are using the infringing copies for a prescribed analysis, perhaps, say, on the prevalence of copyright infringement of certain types of works. Now, if it's an infringing copy, the user must not know this, or if that copy was obtained from what we call flagrantly infringing online location, i.e. an online location that is known to have that's well known to have only infringing copies, then the user must not know or reasonably could have known that the copy was obtained from such a location. So this is how we have constructed and our exception. As I said, it just came into force in September last year. So we are out there talking to businesses and enterprises, not just Singapore enterprises, but also a lot of corporations that are based in Singapore, to see how this exception can be of use of them to, support research and innovation in Singapore. So that is the new laws that were passed. But let me touch briefly on new areas that we could look into in terms of copyright. Of course, the previous speakers talked about computer-generated works, not just we're not just talking about data sets, but we are also talking in the creative fields, as was mentioned about AI-generated music, and we all know that there have been attempts for AI-generated film scripts and movies, and of course, artworks. So how do you protect these type of computer-generated works? Now, a computer program is recognized as a form of literary work under Singapore copyright law, but there is no specific legislation for AI-created works, and we have had no court decisions relating to the authorship of AI-created works, but we have held in 2011 a case from the Court of Appeal involving a claim of authorship by a corporate entity over certain authorial works. And it was held by the Court of Appeal that only natural persons could be considered an author in copyright law. The basis for that reasoning is more of a matter of public policy. The limited term of protection is a bedrock principle of copyright law. And under our laws, the duration of protection for authorial works is statutorily capped at life plus 70 years. Now, if you were to bring in a non-human entity, when does a company die? Potentially, there could be perpetual copyright protection. So the court held that it was not contemplated or envisaged that the author would not be a corporate entity. It must be a natural person. Now, it was acknowledged by the Court of Appeal that in cases involving a high degree of automation, there would be no original work produced for the simple reason that there was no identifiable human authors. Technology has vastly advanced since 2011, and the use of big data, text and data mining, machine learning is so prevalent in almost every industry. That this is an area that is certainly on our watch list and something to be thought about and likely to be consulted in our ongoing study of the interface between AI and IP. So that's it for copyright law, but just to have a more bird's eye view of everything that IPOS is doing, I'll just briefly touch on patents as well. Similarly, we have no
Trina,
specific...
Thank you for being quite brief on this, as we are already,
right.
So timing-wise, thank you.
Yes, noted. I just have a couple of slides. So for AI-related inventions under patents, our laws are very similar to the UK and EU, and our patents formality manual actually refers to the actual person or an individual. We are cognizant of the cases that are happening, and we'll be keeping an eye out. And for examination of AI-related inventions, it's very similar to what Hallie spoke about. We are looking at mathematical methods or algorithms that are functionally limited to solving a specific problem. You will see on these slides, and you can refer to them later in the recordings of the slides that will be shared on some of our programs for accelerating patent protection. And finally, on the use of AI tools in the IP regime, I'd just like to share that we actually, for the last 2 years, have had a commercial AI-powered image-based search solution that we release on both our website and our mobile app for searching for visually similar or conceptually similar trademarks. And we are in the midst of developing other assistive features for patent applications, such as formalities checker. So that's a quick snapshot of what we're doing at IPOS. Thank you.
Thank you very much, Trina. Thank you very much. Most interesting, both in terms of copyright policy and in terms of what you're doing AI-wise. I hope we have a bit of time to get back to the kind of cutting edge use of AI tools by the IPOS. That's very interesting. And with that, I hand over to Pierre Olivier and to the UK view of things. I think you will complement what Trina said on AI IP in the field of copyright, and you are in an excellent position to do so, as you are head of futures strategy at the UK IPO, and one of the office, one of the key specialists on text and data mining laws in the UK. And I also gather that since you hold a PhD in molecular electronics, you are actually understanding those things even from a technical side, in contrast to me, for example. So I'm eager to learn from you on all of that. The floor is yours, Pierre. Go ahead.
Thank you very much. What an introduction. It's an honor to be part of such an illustrious panel and this great event. So thank you very much, and thank you for that introduction. Let me share my screen if I can find it. Excuse me, is that working? Oh no, I need to click here. Is that working now? I hope I'm sharing the right thing.
Yes, looks fine.
Okay, good. I can't actually see what I'm sharing. Right. Thank you. I'm Pierre-Olivier, Head of Future Strategy. So I'm interested in AI as a futures issue and also other things that the UK IPO is sort of looking ahead towards. But I'll skip straight into the presentation, and I think starting off with just a very brief overview. We've, I think, adequately covered this sort of general importance of AI and to IP. So just to sort of reiterate really that the UK kind of recognises AI as a transformative technology, and that it is becoming more prominent and in particular a powerful tool for scientists, entrepreneurs and artists. And actually we're recognising that AI can already act in the innovation and creative process, and how far it can do so is maybe a matter for discussion. I won't dwell on it. I just wanted to point out, or to kind of say that the UK interpretation of AI is, I guess, similar to that, as Heli explained, on the EPO, looking quite broadly when we're thinking about AI, sort of including machine learning, and although recognizing that it's probably typically kind of narrow, we sort of think about the full range of anything that might be considered AI as being sort of pertinent to the matters at hand. So for the UK government, AI is a priority, and we've launched the UK's national AI strategy in September of last year. And recognizing that there are various elements that go into supporting AI, and IP being one of them. Looking at the role that AI plays in innovation, and the role for IP of supporting innovation, I think these things are very complementary. But I'll just go over to the sort of AI and IP timeline in the UK to save a bit of time. So as we said, I'm sort of looking at these things as a futures issue, and as we've said, as we pointed out earlier on, AI itself is sort of more than 60 years old as a field, but it's sort of only recently with computational and data advances that we are where we are, and it's sort of was identified as a futures issue a few years ago. And in particular, from a tools point of view, the UK IPO has developed various AI tools, which I'll talk about next. And then obviously we can't not mention DABUS, but I think we've adequately covered that already. And so in terms of the tools themselves, we have an allocation assistant in the UK. So when patent applications arrive, we have a machine learning based tool for the formalities examiners to be able to allocate the application to the correct field for examination. Then in the timeline, we have the call for views, which we issued to understand stakeholders' inputs across the whole range of AI and IP intersect and interaction. And then we, just over a year ago now, launched our trademark pre-apply advice tool. And just a bit less than a year ago, we published the response to the call for views. And as I've already mentioned, the AI strategy was published, and most recently, we have a more specific consultation on the specific patent and copyright questions around AI and IP, which was opened in October last year and closed actually on Friday, so just a couple of days ago. And actually, sorry, on that, I should say that unfortunately, I'm not in a position as yet to talk too much about the outcome of that consultation, which we're obviously only just starting to digest the input that we've received since it closed only at the end of last week. So Turning to the tools that we have in the IPO, so as I mentioned, the most recent one that we've implemented was the trademark pre-apply advice, which is an AI-powered system which we developed in the UK IPO to support searching and selecting goods and services when someone is thinking about a trademark application. And so it uses, it sort of conducts an automated relative ground searching using OCR, and also it has an image recognition capacity to identify related and similar marks to one that is being considered as a trademark. And it has been very successful and leading to a much quicker trademark examination and a better quality of applications in terms of the sort of scope of areas that are being requested for trademark to make them more appropriate to the mark in question, and also as a better identification of existing similar marks. The other main tool that we have in place is this machine learning patent application tool, which automates a significant bit of the patent application assigning process to get it to the relevant patent examiner. So it's not an entirely automated system. There is some human decision making is needed, which is why I've sort of called it more of the machine learning rather than a kind of AI as such. But so it presents a sort of a short list of areas for a given application, and allocation accuracy is increased from 60% to 80% with the use of this tool. And the allocation is now conducted sort of, there's a time saving been measured of 50%, at least 50% in that process. So that's been a very successful tool for the efficiency of the IPO's operation in that step in the process. And then lastly, we conducted a pilot on an AI assistant tool for patent prior art searches. And although this is something that we haven't implemented, the result of the patent shows that the AI algorithms can offer some benefits for prior art searches. But we found that the need for examiner involvement in both the sort of input to the algorithms and interpreting the results that the AI system produced meant that the sort of efficiency gains were not as sort of significant as we might have liked. And I guess partly, we have a sort of pool of expert examiners. So for the time being, we have no plans to continue studying the system that we were working on there, but we are working with the EPO on their sort of next generation AI search tool. So we're looking forward to further work and collaboration in that space. So that's it for the tools that we use in the IPO, and I'm going to, in the UK IPO, and I'm going to move on just briefly to talk about the consultations that we have conducted. So in 2020, we asked whether the IP framework, or sort of how the IP framework interacts with AI and AI innovation. And in particular, the questions around inventorship of patents and AI generated works, and whether they should be protected by copyright. And, are these protections adequate already? Is copyright a barrier to machine learning or, AI system development? And also we ask questions around trademark designs and trade secrets as well. The conclusions to this call for views was that the overall picture was very positive, seeing the AI and machine learning sort of supporting human researchers, creators, and inventors to develop new technology. So, extremely positive for the innovation landscape. But there were concerns around the role of humanity in the creative process, and the fact that sort of, as I think has been touched on previously, the IP system, the sort of fundamentals of it is to support and encourage human creativity and invention. But overall, there was a thought, especially in the sort of trademark and design spaces, that our existing systems within the UK were sort of flexible enough to manage the challenges of developments in the field of AI. So, for example, there are questions around liability, like if an AI system causes some harm to someone, or can commit some infringement, then how would one find liability of that? But the feeling was that the sort of existing law can kind of manage with, even with these new developments. The areas that were sort of determined to be followed up were around patents and copyright, which is the topics that we've already touched on today. So I won't dwell on this, but the point is that we consulted in further detail on the questions around computer-generated works, where we have existing protection for these kind of works within the UK, and I'll come on to that. Questions around text and data mining and exceptions, which, along the lines of that which we've heard from Trina just now. And also of course, the questions around patent inventorship, as we heard from Heli. So moving on to the UK legal framework, and I'm focusing on copyright, our sort of where we are on patents is sort of mirrors, I suppose, that which Heli has set out for the EPO, in that thinking about the sort of Davos cases, the Court of Appeal found that a human did need to be named as inventor, and so far, we await further developments. There's a further stage of appeal which may or may not take place, but for the time being, I don't think I need to add anything more to the information that Heli has already set out. So looking at the copyright side, the UK does actually have a provision in its Copyright Designs and Patents Act 1988, which grants a 50-year copyright protection to so-called computer-generated works. And these are works which are generated by a computer such that there is no human author of the work. And this was put in place, quite a long time ago now, so 1988, and it was thought at the time that it was the first copyright legislation, that dealt specifically with the advent of artificial intelligence, which was only one of the elements. There are other materials such as sort of weather maps and expert system output, which was, I guess, maybe the main drivers at the time, but certainly the idea that artificial intelligence systems could generate works which would merit copyright protection was there when this legislation was brought in. Having said that, we actually, in all this time, don't really know to what extent the provision is in fact used, or what types of work are generated without human creativity. Because where there is human creativity that can be identified, then these will not be computer-generated works, but they will benefit from copyright in the normal way as any other human work. So the reason that we're sort of not really sure about this is because there are very few cases that have come up in all this time where there's questions of whether something has been a computer-generated work or not has been brought before the courts. So we don't know if this is because the system is working very well and no one has any legal problems with it, or because it's in fact just not used really at all. So that is one of the things that we're hoping to get a bit more information about as a result of our recent consultation. And but we do recognise that there are some legal issues with the provision that we have, mainly around the test for originality, where the legal tests in the UK all point to human characteristics for originality around the sort of personality of the author. And these are not things that you can generally attribute to an AI system. So it's not really clear exactly, given the computer-generated work still needs to be original, but how would such originality be shown without some human author? So we sort of end up in a bit of a sticky situation in trying to interpret that. There are also questions around economic incentives. As we've talked about earlier on, the marginal cost of an AI work is negligible, and are the economic incentives provided by intellectual property rights appropriate for these kind of works? And then there are the philosophical arguments around the sort of human element of creativity and IP protection around that, and what would be the effect of AI generated works on the sort of value of human creativity? So there's quite deep questions to be looked at there. Another element, which was, Peter described me as an expert on this. I'm not sure that's quite true, but on the text and data mining element, and the flip side of copyright protection potentially causing difficulties for AI innovation and development. So in the UK, we introduced a text and data mining exception for non-commercial research in 2014, and it was reviewed 5 years later. And it was well supported by researchers, but there were various issues identified for sort of, in particular, around the distinction between commercial and non-commercial research, and also an application to database. So at the moment, databases which are subject to copyright would fall within the exception, but databases protected under the database rights would not. So there's potentially some difficulties there for people wanting to make use of this exception. And the consultation is looking at a broad range of options on licensing and exceptions, from a sort of small enlargement to cover commercial research, right through to something closer to the Singapore system, which is obviously a much broader exception. And as part of that, we're looking at the various different models that are in place internationally, because there's quite a range of legal arrangements in this field. So that is really what I wanted to say on those things, and I'm looking forward to the debate. So I think, without further ado, thank you very much.
Thank you very much, Pierre. That was very, very interesting and multifaceted, and I completely see that we have to do a special podcast with you in 3 days' time when you ran through all the results of that consultation. That will be most interesting to discuss also maybe at our June event. That was really a very good tour d'horizon of what is going on in the UK. Before we switch to our academic experts, we do need to briefly cover what Switzerland has done in the area of text and data mining. And for that, I would give briefly the word to Sabrina Conrad. She is the Deputy Director of the legal office at the IPI in the section of copyright. And she was also one of the kind of driving persons in the recent Swiss copyright law revision. So Sabrina, thank you for introducing us briefly to the text and data mining rules that are new in Swiss copyright law, Wissenschaftsschranke, as we would call it correctly in German, I think.
Absolutely. Thank you, Peter. Ladies and gentlemen, good afternoon. With a glance at the clock, I will be really very brief. As Mr. Odor mentioned already, a so-called exception for scientific research is in force in Switzerland since 2020. The exception allows, under certain conditions, the reproduction of works for the purpose of scientific research. And as I learned today, the exception has similarities to the exception in force in Singapore. But given the time, I will only address two aspects of the exception. First, I will have a look at the aspect of the financial orientation of the research. And second, I will refer to AI training data. On the first point, the mandatory exception does not distinguish between commercial and non-commercial research. Research often serves several purposes and has different forms of funding. It is difficult to draw sort of a clear line between commercial and non-commercial research. So for instance, how would you consider a cooperation between universities and commercially oriented companies? What about a university research project that unexpectedly results in a commercially exploitable outcome? By allowing commercial research within the scope of the exception, Switzerland avoids difficult questions on delimitation and therefore creates legal certainty. On the second point, the exception is technology neutral and thus goes further than a specific exemption for text and data mining. It can therefore be interesting for AI because AI training data may be protected by copyright. So if the conditions are met, the exception for scientific research can also cover acts of reproduction that are necessary to train the AI. In this respect, it is important that there must be legal access to the works used, for example, based on a subscription. In addition, the AI must fulfill the purpose of scientific research. An AI that learns from works in order to generate artistic output is unlikely to fulfill this purpose. To summarize, Switzerland's exception permits reproductions of works for the purpose of scientific research, regardless of who is doing the research and how that research is funded. The exception can be helpful regarding machine learning of AI. However, it remains tied to the purpose of scientific research and does not grant a right of access to works. Thank you for your attention, and I already hand over back to you, Peter.
Thank you, Sabrina. Very interesting. Also, thank you for the brevity of your concise explanations. I do understand from that the Swiss text data mining exemption is going farther actually than the EU the provisions on that. So it's also quite interesting for that reason. And I could imagine that, for example, Gaetan will have something to say on whether this makes sense economically later on. But in order for him to be able to do so, we will have to continue right away with our next presentation, coming from Avi Bernstein, a very dear colleague from the University of Zurich, where he's a professor at the Department of Informatics, and one of his current research focus is actually on semantic web, data mining and machine learning. So he's most excellently placed to give us an informatics view on the things we're talking about, while, as we all know, lawyers are particularly good at speaking about technologies we don't really understand. You do. So you will tell us about whether these machines are actually innovative and whether they are therefore they should be treated as being so. Before I hand over to you, I would also like to mention that you are one of the founding directors of Zurich University's Digital Society Initiative, DSI. So you're also thinking very actively on how AI impacts our lives and societies. So thanks for being here, Avi, and the floor is yours.
Peter, thanks a lot. I guess you're seeing my screen now. It is a great pleasure and honor to be here and talk about these issues. Please keep in mind, I'm just a humble computer scientist and not a lawyer, so any mistakes that I might make in that respect, they're obviously all mine. I was asked to talk a little bit about AI-based intellectual property, and an interesting thing I came about looking for it is a painting that was sold on Christie's. It was estimated to fetch about $7,000 to $10,000 US. It ended up fetching $432,000 in an auction in 2018. And you can find the link here at the bottom of the slide. Interestingly enough, the painting or a file of the painting is available on the Wikimedia Commons. And the reason is that the painting was completely computer generated with a artificial neural network. Indeed, the page on the Wikipedia page says about the licensing thereof. This file is in the public domain as it is the work of a computer program or artificial intelligence. It has no human author in whom copyright is vested. Even though that was found, somebody was prepared to pay a lot of money to buy that piece of work. So that gets me to the questions that Peter asked me. So what is artificial intelligence? And I should elaborate this from the point of view of a computer scientist. And how would AI go about generating intellectual property? So let me start with a statement that AI, or artificial intelligence, has been a dream of humanity for literally millennia. We have a lot of attempts of mythical figures or Frankensteins, etc., acting in human-like action, as the golem here shown on the left. And then in the beginning of last century, with the advent of the computers, this suddenly became within the grasp of the possible. Specifically, the whole endeavor started in this beautiful villa out here in Bletchley Park, where a bunch of researchers and people from the Allied forces got together to crack this encryption machine, the Enigma, which was an encryption machine built by the Nazis to encrypt their messages. Concretely, the Enigma would take a message such as this: a convoy ABC will be attacked today at 5 p.m. and encrypt it in a set of letters garbled up in a way not understandable by most of us. Now, what the people that actually did crack the Enigma realized is that the difference between understanding the text or not would be the difference between sinking merchant marine ships and a convoy that would get to its goal in a successful way. Now, if, however, you do act on every encrypted message, it would become very quickly clear to the Nazis that the Enigma was cracked, and they would devise another method of encryption. So what they realized is that in order to maintain the usage of their cracked encryption method, they need to be in a state where it was unclear to the Nazis whether the Enigma was cracked or not. So they needed plausible deniability. Now, what does this whole detour into, Second World warfare have to do with artificial intelligence? One of the people in that team was a man named Alan Turing, and he actually devised something called the imitation game, which today colloquially is called the Turing Test. And the Turing Test essentially says that if a human being that can only communicate with a counterpart by sending messages and receiving answer to these messages cannot discern whether it has talked to a machine or a human, then that machine has passed the Turing test. It is able to mimic a machine. If you go to the Wikipedia and you look at other definitions of general artificial intelligence, I have to say, you will find other tests such as the coffee test by Steve Wozniak. A machine is required to enter an average American home and figure out how to make coffee. The robot college student test, a machine enrolls in a university taking and passing the same classes as humans do, or the employment test where a machine passes employment. Now, the important point for this definition, it makes no claim whatsoever about the technology used to achieve this goal. So essentially, the core of it is that it wants to act like a human being. And interestingly enough, you can now use this either to understand how humans act, if you act like a human being, or to see whether a machine can pass the Turing test. Today's AI research mostly actually doesn't try to mimic a human actor, but a rational actor. So it really follows the goal on the lower right quadrant here. Can we build a rational machine that will have rational actions? Please note that this definition is in very stark contrast, for example, to what the EU lawmakers are proposing in their AI law, where in the appendix, in our Annex 1, it has a definition of what it understands AI to be, which is machine learning approaches, including supervised, unsupervised, and reinforcement learning using a wide variety of methods, including deep learning, or logic-based approaches, etc., or the third point, statistical approaches, Bayesian estimation, search, and optimization methods. Now note that most computer programs today employ some type of search or optimization methods. Okay, so what we can see here is that the computer scientist's view is more like I'm trying to generate intelligent behavior, whereas interestingly, the lawmaker in the EU is trying to propose a method that proposes the methods that are being used as a way to delineating what artificial intelligence is or not. Now, how could you use AI now to produce intellectual property? Now, we generally use three different methods to build AI system: deduction, induction, and analogies. Let me just quickly run through all of these and see how they might be used to generate intellectual property. Deduction is usually a way to use logic or some other search method to generate answers to certain questions. So for example, if a human would ask, can robins fly, with a knowledge base in the middle, the answer would be yes, robins are birds, and birds move by flying, hence robins can fly. If you take this and want to invent a method for translating texts, you could use the method that we devised here a couple of years ago that combined machine translation and human actors that only understand the target language. You take a text, you divide it into its constituents, use a machine translation tool to translate these. You then use the target language humans to improve on the fluency as well as on the grammar, and you get a target text. Now, for each of these steps, you could have a method, for example, Google Translate, DeepL, or some other machine translate. You could divide on the sentence level, on the word level, or on the paragraph level. You could use a translation method such as Google Translate, DeepL, or some other machine translation method, and you could find default alternative for fluency correction and grammar correction. What you can see, what I'm getting at, is you can now use each of these alternatives and recombine them into various methods. And eventually you will get a large number of alternative processes of how to achieve this goal. Essentially, you could generate all possible translation processes that follow this template. Or if you take an image as a collection of pixels, you could generate all possible images by just alternating the pixels, by just searching the space of possible solutions of what a nice picture is and not a nice picture is. So the question is, how do you define what a good picture is and what not a good picture is, or what a good translation process is and what not? Now, what you could do is you could generate all of them and just see how well the translations are by auto experimentation. That would, however, require you to look at lots of text. So another method would be to use induction. The current flavor of the month in induction is something called neural networks, which use standard regression techniques such as linear regression that we all learned in school, combine them with some function that then says when a result should activate the neuron or not, such, for example, as this sigmoid function. And then you take the input values, you have a layer of a bunch of these neurons that get the input values and will learn all the parameters, and you now add more and more layers to this, and then you have an output value. And for example, you could look at all the people who were on the Titanic and then learn whether they survived their trip or not, and then build a predictor function for surviving or not. Alternative, you could try and predict the value of each pixel of a picture and then learn the style of a painting, and then take, forget this, Pete. And then you could, for example, learn the style and then repaint the Mona Lisa in the style of Starry Night of Van Gogh, or The Great Wave by, sorry, the name evades me now, but I'm sure one of you remembers who The Great Wave was painted by. The third piece is used by analogy, and that's often used when we have recommender systems. So for example, if we look at the lower two viewers, they both watch the BBC as well as SRF, the Swiss first TV station, and you could now use this analogy to recommend this viewer here also you watches SRF to also watch the BBC and get recommendations out of them. If we combine all of these methods now, you could specify a problem, use search to plan and recombine new solutions, and then run the most possible solutions and evaluate whether they're good or not. If they're good solutions, take that as your result, and if not, recombine more of these solutions. We have done that to find better translation processes, and others have done that to do other things. Now, can it produce actually good results? I think that has been answered ever since the publication of this paper, where Ross King and colleagues built a robot that automatically performs science, the result of which they could publish in Nature, where the robots did research in the area of yeast. Now, what do humans think about this? Do humans think that AI designed goods are better or worse? There is actually a line of research currently in the human-computer interaction domain that looks at this. Last year at one of the big conferences, there was a paper that talked about whether AI or human-generated artworks are being seen as liked or beautiful, should be novel, and have a meaning. And it was found in this purely empirical work that there is a somewhat of a negative bias against artwork not produced by human beings. In the journal, in the journalism domain, there was a study published last year. I guess my brain is still in 2021. Apologies. Whether algorithms in the newsroom, and whether they asked 300 subjects to assess both the credibility, the source of the message of sports and finance news items, and they find that AI-produced sports news were deemed to be more credible than human-produced sports news because they were deemed to be less biased. On finance news, that was not the case. So, in closing, I hope I could show you that there is a somewhat of a mismatch as to what people understand by AI. And for me as a computer scientist, is anything that would generate something that people would look at either seeming a human product or a rational product. Secondly, can AI produce stuff that we would see as valuable? I would argue that has long since passed and can be answered as yes, with a clear and strong yes. And if it is a domain where that's not yet possible, it is very likely that it will be able to do so in some point in the near future. Will it be able to have complete artificial general intelligence? I would say one of the jokes in AI circles is there is one constant in artificial intelligence, that is that we will have artificial general intelligence in 20 years. And the 20 years is the one thing that's constant. On the other hand, we are getting increasingly concerned that we need to think about what are the moral, ethical implications of having artificial general intelligence, and what should we think about how can we ensure that that artificial intelligence will behave according to our standards. Thank you very much.
Thank you very much, Avi. Even to me, that was a very clear presentation, and one that very also clearly made the point of how innovative these beasts apparently can be. And maybe the 20 years, time is relative. So maybe the upcoming 20 years prove to be a little bit shorter than the preceding 20 years, but we will see. And I'm sure we will address this in a round of comments after the next presentation, with which I turn over to Gaëtan de Rassenfoss, our last speaker before the discussion. Gaëtan is a professor at the College of Management of Technology at the École Polytechnique Fédérale de Lausanne. He's also visiting researcher at the MIT, and if I may say so, a rising global star in the economics of innovation and also in policy consultation in that field, because he has done many studies and consultancy work for many public and private bodies all over the world. So he will give us an economics take on whether AI inventions ought to be patented from an economics perspective. Gaëtan, please.
Well, thank you very much, Peter, for that very generous introduction. And so indeed, over the next 20 minutes, we'll be discussing or taking an economic perspective to wonder whether we can find arguments for or against the patenting of AI-generated invention. So in contrast to the debate in the legal scholarly literature, where we wonder whether invention can actually be patented, here we'll actually take more like a normative perspective and try to think of economic reasons for an answer. And I hope I will be as clear and as pedagogical as Avi just before. But long story short, the answer is, I believe, on balance, that we have a strong case to allow the patenting of AI-generated invention. However, perhaps with a type of IP rights which is not as strong as a patent. So let me walk you through the reasoning that has led me to that conclusion. And let's start with considering, in a very generic term, an invention machine. We'll assume for now that this invention machine creates invention at zero cost, right? So in a sense, inventions are fast and cheap to produce. We also assume that the invention machine cannot commercialize this invention itself. So we are living in a world where we have invention developers on the one hand, and invention implementers will actually take that invention and invest further in it to commercialize it and put it on the market. And we also assume for now that inventions are in the public domain. So we can think of this thought experiment so far as being an AI software producing inventions that cannot be patented, and these inventions are not secret but public. Then the question we need to answer here is, would society be better off if we would allow patent protection on this invention? And so to have an element of answer, let's actually go back in time and call the invention machine a university. Because it used to be the case, in fact, that before at least here I'll take the US example, that before the 1980 Bayh-Dole Act in the US, government would retain title to inventions that were federally funded and would license them only non-exclusively. So taking our analogy, we don't care so much about the zero cost, but at least it has been funded, the inventions have been funded by public money. Universities and public research organizations cannot commercialize this invention themselves, but invention here are in the public domain. So, licensees need to, or would be startup and companies that want to commercialize this invention would actually need to get a license, but these licenses are non-exclusive. And that situation actually led to, around the 1980s, fewer than 5% of federal inventions being licensed. So that's a tiny proportion. And ideally, we would want most of these university inventions and federal labs inventions from the NIH, typically, for instance, to be licensed and to be put in use. And the reason here for that very low take-up rate of publicly funded inventions, it's known in economics as the free good problem. And a free good is a good that is available plentifully for everyone to enjoy, like air. And clearly, when a good is free, no one can actually possibly sell air. So no sensible business model will be made out of a free good because it's free, right? So who actually buy them? The picture changes when we introduce scarcity. And here, I'll give you an example of a Swiss startup called Swiss Breeze, which actually sells air. So according to the website, so here I'm doing some promotion of this startup, but they sell the best, most pristine and freshest Swiss canned air gathered in the most beautiful and remote lake and mountain regions. So clearly, fresh air and Swiss fresh air here is a scarce resource in polluted cities, where we can actually conceive wealthy consumer willing to buy this canned air to have a shot of fresh air. And what the Bayh-Dole Act, so back to our university example, what the Bayh-Dole Act actually did, it introduced scarcity in federal invention by allowing for exclusive licenses. So now all of a sudden, firms didn't have to work with non-exclusive license, knowing that everyone could compete on the same invention, but they actually had some exclusivity to develop the invention, be it a geographic exclusivity or a market or industry exclusivity. So the argument so far is that if we don't allow IP, AI-generated inventions to be patented, well, we are not in a world of scarce resources. So few technology implementers would want to invest in this further development, so the R&D and marketing activities to bring the AI-generated invention to the market. And that's where you could have one objection. Say, well, if firms cannot patent AI-generated inventions, they might simply keep it secret. And indeed, in that state of the world, secrecy introduces scarcity because only one person actually knows the invention. There are, however, a couple of problems with secrecy in that example. I mean, with secrecy in general, but in particular in our case here, it's, well, generally speaking, secrecy is not always an effective protection mechanism. So secrecy can actually work fairly well in some instances. But think of goods that can, or inventions or products that can be easily reverse engineered. Secrecy here is simply not an option. We also know in terms of markets for technology, and so transacting, so selling technologies or licensing technologies, that secrecy actually is not a very effective means to transfer technology from one party to another. And here, patents and IP rights are actually a vehicle that allows firms to trade and license technologies. And from a social perspective, from a global welfare perspective, secrecy limits the learning opportunities from others. So what we call in the economic literature as the knowledge spillovers. So essentially the fact that inventors sometimes actually learn by reading the patent documents. So I'm not saying that secrecy is not an option. Secrecy can actually prove helpful. However, secrecy cannot be the only mode of protection. And clearly we feel that we need something more. So of course, I've come to that conclusion by using a very specific and narrow case. So now let's try to relax this assumption and see how the picture changes once we want to relax some of these assumptions. And so here I'll start with relaxing the first assumption that these inventions are created at zero cost. It's actually not an unrealistic assumption because the promise of AI is actually to produce invention cheaply and quickly, right? In that sense, the common saying would be that the machine doesn't need to be incentivized. And that's very much true. However, creating the machine is presumably costly. And so here we might need some, well, to wonder about how we could actually think of, incentivizing the creation of the machine in that sense. And considering this actually strengthens the case for patent protection, because without protection, the output of the invention machines becomes difficult to transfer. So that's the secrecy that we discussed, which reduces the incentive to invest in the creation of the machine in the first place, because essentially there would be no market to sell or transfer this AI-generated inventions to other actors. And if we take the reasoning to the limit, if invention developers are unable to transfer the inventions to third parties, there is simply no financial incentive in producing these inventions. So that's kind of a backward induction argument, where here we need patent protection on the output, so on the AI-generated inventions, to incentivize the creation of such machines in the first place. Of course, then comes the question of how much protection to offer, and should we actually offer a protection that is as strong as a patent? We'll actually get back to that. And again, to recap the argument, argument number 2 here is, without patent protection, few technology developers would have the necessary incentive to invest in the creation of such invention machines. And that's where you can bring yet another objections. So far, we've assumed that inventions developers are different from invention implementers, but sometimes the owners or the creator of these invention machines may actually decide to commercialize inventions themselves, right? So that's what we call these integrated innovators. Well, that's another assumption that we will relax. So we had assumed that the invention machine cannot commercialize this invention itself, but now we will assume that invention developers actually sometimes may also implement these inventions. And clearly in the Bayh-Dole Act and the university example, it had to be the case that universities and PROs do not commercialize inventions, put the invention on the market themselves. That's not their mission. Here, of course, the picture is different. So the analogy stops, has to stop somewhere, and it stops here. And if we consider that this time we have integrated developers, so invention creators are also implementers, that weakens the case for patent protection, of course. And at the limit, if all of the developers were also implementers, the need for protection will actually be weaker, but not null, because as we have discussed before, secrecy cannot be the only mode of protection, because for some inventions, it will simply not work. But in addition to that, and perhaps more importantly, that is actually not the trend that we're seeing in, when we look at the innovation process and how firms organize their innovation. So there are two mega trends, which is known as open innovation. So it's the fact that firms actually transfer more and more innovation from their own boundaries or their own firms to other firms. So they license in and license out technologies. They take ideas from various places. So the innovation process is more open in a sense. And that has been also sustained by the stronger importance of markets for technology, which is the formal way in which patent rights or technology more generally are being transferred. And it turns out that roughly 12 to 16% of US patents and EP patents will be transferred at least once during their lifetime. So that's some research that has been done 5 to 10 years ago. And there's all reasons to believe that AI will actually reinforce the specialization of actors into innovation creator and innovation developers. So producing this AI machine, essentially these invention machines, requires a totally different set of skills that many companies don't necessarily have. And implementing these inventions require yet another distinct set of skills. You need to reach out to marketing department, you have to have distribution channels. So it's very likely, in fact, that AI will further exacerbate the specialization of actors into implementers and creators. So here again, to recap argument number 3, somehow the case for patent protection is weaker if we consider integrated developers. However, we cannot rely on secrecy alone, in a sense. And in addition to that, we know that not all innovators are integrated, and the trend might actually go into the opposite direction. So now let's try to think of what we could offer. So here I'm maybe projecting ahead, like a couple of months ahead, in proposing some policy solutions. And that's just one idea among potentially many others. But let's actually take the invention machine seriously and see what will happen if we can indeed produce invention cheap and fast. Well, we will have, taking invention machine seriously, we'll have a tsunami of inventions, potentially. A tsunami of invention would mean an overloading of patent offices, potentially, a concentration of IP rights, among selected actors, and perhaps also some patent-free zones. So let me discuss each of these issues in turn and potential solution. Regarding the first one on the overloading of patent offices, you may have heard the term of global patent warming, which was used by Kieran McGinley at the EPO in the mid-2000s, when EPO and USPTO were receiving a number of applications that was difficult to deal with in a timely manner. That led to increased pendency and the associated consequences for innovators of market uncertainty, maybe delayed R&D investment, and so on. And that was just with human-made inventions. So now if we move to AI-generated inventions, we might very much have an overloading of patent offices, which would be the one solution we could think of, would be that instead of examining all of these AI-made inventions, patent offices could examine and certify the software or the machine. Inventions from certified machine would be presumed valid, knowing that the machine has been vetted in a sense and has been led to show to some consistent logical findings, for instance. And these patents would be given a special status. So now instead of examining millions of applications that would be AI generated, we only need to certify the machines, and we'll assume the inventions would be valid. But of course, maybe pending some opposition or some specific tools that we can put in place. Element number 2 of a tsunami of invention would be potentially a concentration of IP rights. And especially here in the case of integrated innovators, so firms that both invent and implement the invention would be offered the opportunity to amass vast portfolio of patents, potentially blocking entry and preventing competition. So giving something as strong as our current patents to companies that have the ability to produce hundreds of these inventions quickly is somehow terrifying. So maybe we can think of special status for these AI invented patents. Maybe they could be all of these inventions arising from this certified machine have to be available under front clauses, for instance, or maybe should receive a shorter legal validity, not the 20-year protection, but the 10-year protection. So essentially, as soon as we are able to differentiate an invention that is being made in a traditional way by a human versus an invention that has been made automatically from an invention machine, we can think of different IP regimes to counter some of the negative effects we could think of. Finally, and here I have no solutions, but cheap and fast invention also creates the possibility of prior art flooding, essentially publishing online millions, hundreds, thousands of inventions in a given technological field, which would not only make patents more difficult to obtain for inventors, raising the obviousness level, for instance, or maybe a traditional inventor would not be able himself or herself to go over the prior art and will actually invent something that has already been invented, but would also be more difficult for patent offices to examine simply because they have to go through more inventions. And so here it's potentially destroying the overall purpose of the patent system if we have just too much prior art available in a given technology area. It's not clear how the patent system and inventors will be able to keep up. So on balance, I believe that economic reasoning suggests that AI-generated invention should be allowed IP protection. However, and here taking invention machine seriously, it's not clear that we should have the same IP regimes than we have for patents. Maybe we could think of certifying the machines with a special status for AI-generated inventions. I'll stop here and I thank you for your attention.
Thank you very much, Gaetan. Towards the end of our workshop, a lot of food for thought. In addition, also, I like very much your kind of approach to think not only whether we can apply the IP rights as they exist today to AI supported or even AI generated innovations, but also whether, you know, we should come up with a new toolbox, with a new set of rights and limitations that would allow us, you know, to tackle these new phenomena. I know that we are more advanced in time that we would probably wish to be, but taking a couple of extra minutes, which is already a good tradition in this workshop series, I think we do have still some time for 1 or 2 rounds of questions. And before I hand the discussion over to my IPI colleague Hans-Uli Stamm, who is also one of the inventors of this workshop series and of the entire project, I would like to right away kind of push Gaëtan's suggestion of a new type of IP rights back to the agency representatives. Overstating things, I just heard 2 presentations by 2 professors saying, yes, they are innovative, these beasts are innovative and we should protect this, and you know, we may have to adjust our toolbox, but otherwise let's do that. And before that, we heard quite a lot about maybe we should not acknowledge AI systems as inventors, and we should not really alter our legal framework. Yes, we may need some specific copyright exemptions for text and data mining, but rather, you know, a conservative approach from the IP offices. So this is an interesting divergence that I can see here, and I would like, having heard from our economics and technical experts, I would like to hear from the IP office representatives whether they have changed their minds and whether they think that maybe it should be about creating new IP rights for new AI systems instead of, you know, defensively, again overstating, defensively not applying existing tools to the new things that come up. I don't know who's supposed to start. Maybe we just follow the order of the presentations, and Ulrike Till would go first. And sorry for that provocative question.
No, it's a very good question, and certainly one of the questions that we raised in the revised issues paper, of saying, does it need new rights? I guess there are a couple of things that spring to my mind without a definitive answer. But when we, in the last WIPO conversation, when we looked at data and IP, we asked the question whether there should be a new IP right for data, given everything we said about investment, and we ran, just by anecdote, a little survey by the end of it, and we asked participants whether they thought the IP system is okay the way it is, whether it needs a new right, and the great majority of answers that we got were saying, well, it might need tweaking a little bit, but let's not go overboard completely. So that probably gives you the sentiment of the things that we've seen in discussion. I mean, certainly one question that I have in my head, and that comes a little bit from a past life of an IP litigator, there is a real question if you start creating rights that are different from AI to humans of evidentiary burdens. How do you know it was created by a machine versus how was it created by a human? And how do you distinguish the 2 rights applying to it? So on that basis, I just raised the question when we talk about creating new rights, it's thinking that through and what is going to be the ultimate consequence. And I guess that comes back to the question of the IP system actually being very complicated, very interlinked. And it's one of those things, everywhere you tweak it, it will have consequences across the system. So maybe think it through properly. That's a very wishy-washy answer of saying no, yes or no, but we really have to think about it properly.
Okay, thanks a lot. Heli, what's your take?
Thank you. I'm absolutely happy to have been able to listen to all these discussions, and and also all the analysis of Gertan Abi and the contributions to all the colleagues. Of course, here are a lot of questions which have been discussed, as Ulrike mentioned, also in the WIPO conversations, and back to the point that the IP system cannot be seen in isolation from any other systems. I have had, since 2018, the pleasure to not only to learn all possible things about fuzzy logic and AI and all the technological aspects. In a private conversation, I can give you a lot of jokes about it, but maybe not here. Still, so it all comes actually to the question, how do we see IP system in the society? How do we see the legal system in the society? And what are rights and obligations there? And who can be subjects and objects of rights and obligations? And how do we administer, how do we monitor, and how do we follow all this? And this goes very much to the same that Ulrike mentioned from her experience as a litigator. So we have done a lot of mind mapping about what could be, what could that all mean? And of course, I have been listening to all these all these arguments that AI can create a lot of prior art. But of course, AI can similarly be there searching and blocking the prior art. So these kind of floating the prior art and the state of the art. So there are always two sides of the coin. And then if we go into the mind mapping, so just imagine in the practice exactly the question, who would be then the inventor if we are, for example, talking about the traditional, let's say, AI creating some kind of technical solution where they normally use hardware, software being a computer program, and some data, and with different owners of the software, different owner of the hardware, different owner of the data. And what would that mean for the contractual situation afterwards? I'm not even talking about that kind of patent law concepts like priority right and who has the priority right coming from Paris Convention, but what would it mean for the contractual negotiation basis in the society? What would it mean for the rights of all the different parties involved in that, all the obligations? And how would the inventorship be then defined? Then when we are asking about what kind of rights should be there. So of course, in the IP system, we have a tradition of sui generis rights. We also have a lot of experimental values concerning those sui generis rights and the global acceptance or the global usage of sui generis rights. So I don't think that I need to go more in details here because those details are available in many on WIPO website, for example. And so that is then also the question when we were discussing at the beginning of this session, that all there needs to be some global, there needs to be for patent system being industrial policy, right? Industrial property, not policy right, excuse me, industrial property right, it is global. We are all living in a harmonized global world, and then to come into agreements and as Felix Ador requested at the beginning, which is very clear principle that we need here. So then we come to all these questions, and but these discussions are really fascinating, and the mind mappings that you can do here about contractual law, about even human rights, employment law, all that, it has dimensions to be thought about before we go into further details of defining what to be done. International law, international contract law, all that. It's really a fascinating topic. And then on the other side, we are talking about the fourth industrial. Now comes, I'm not saying that this is a conservative or defensive point. I would like to disagree with that introduction to the discussion part, because I don't feel that patent system can ever be defensive or conservative. Patent system, I'm speaking only for patent system here. We are now living the fourth industrial revolution. Patent system has passed through the past three industrial revolutions with very little changes in the basic principles, starting from my favorite, namely the Venice Act, which never entered into force, but which, to my understanding, still has very fundamental principles written in it. And therefore, when we look at it and what has been the development and how patent system has replied and adapted to the changing world and changing developing technologies and everything what happens in the world around us, I won't ever say that patent system is defensive or conservative. It is adaptable to the movements, to the developments in the society, in the technology. And therefore, I'm very happy also from the part of the European Patent Office that our enlarged Board of Appeal didn't even define what is technical or technology, because that has been defined, that has been developing. And the patent system has been adapting to all that. Thank you.
Thank you for the well-deserved scolding, Haley, and also for pointing out all those relevant facets. Let's go on. Trina, what is your take on things?
I mean, it certainly is an interesting proposition, and it's IPOS has only just started looking into this area. We have been focusing much more on copyright initially, and I would say that we are not averse or conservative such that is immediately we would say no, there cannot be patent protection for AI developed inventions. And in fact, in one of the earlier whiteboard conversations, one of the questions that were posed in our contributions was even could we even look at maybe joint authorship, since there's so much pushback as to whether AI could actually autonomously really develop inventions, and a lot of it we're looking at AI assisted inventions, you know, concepts of joint authorship. But it is still a very new area, and a lot of the preliminary findings we're getting from our study indicate on the ground from the actual companies, both large and small, is that are we truly at the stage of general AI? Can we say that that really is autonomous AI generated inventions? And I know that without going into detail, there's also some commentary about whether DABUS is truly AI, autonomous AI invention. So I would say that we are not averse to it, but it's, as Haley said, you know, the IP system, it doesn't exist in a vacuum. There are a lot of, it links to a lot of things, human rights, legal personality, and going back to the fundamental philosophy of what the IP system is. But I would say we are not opposed to moving on and adapting. And as we have seen in the copyright regime, the original intention of it, of protecting the individual human creator, has morphed quite rapidly into protection of enterprises as well. And that balancing act, or what we like to call the Goldilocks zone, neither too hot, too cold, not too hot, not too cold. Where is that balance that you protect human endeavor in various forms? And AI, in a way, is an output of human endeavor, because, you know, it generates from what we have developed as well. So I wouldn't say we are defensive or conservative about it. And it's certainly food for thought, which we are taking on board. And that's why we are very happy to participate in webinars like this and listen to so many views. Yeah, thank you.
Thanks a lot. Pierre, what's your take on conservatism and the AI IP system and AI?
Well, that's an interesting question. I was going to answer your original question around whether we need to be rethinking the whole system for these kind of AI inventions, and actually that is one of the options that we put forward was a kind of separate patent-like but not patent right for AI inventions, but without overstepping the mark. Sorry, my cat is joining the workshop. Without overstepping the mark, I think it's safe for me to say that this wasn't a very popular option amongst stakeholders from the conversations that we had. So I'm not sure that in practical terms, even if academically it might be the right thing to do to look at some protection short of patent protection for kind of AI type inventions, I don't think that realistically it's something that we will be taking forward necessarily. Having said that, I think that to me answers where I think maybe I differ in terms of the sort of conservativeness. I think that does partly indicate a bit of a kind of conservativeness around the IP system, and people who are involved in the system do like the rights that they have and the sort of clarity and certainty for things that they are used to not to change so much. So I think there is a certain incentive to avoid changing the system. And to be fair, the system has worked very well, as Helia said, for different generations of new innovations and revolutions of innovation. So maybe that's fine. But I think that there is a bit of nervousness about trying a new thing. And I do wonder, again, maybe not representing the kind of IPO, the UK IPO view here, but it does make you wonder. And as Peter Thompson has said in the chat question, what does society need in terms of protection of AI generated works? And I think that is the question that we're trying to say. How does the IP system support what is best for society in this question? And I think that is quite challenging to the IP system. Whether that's a sign of conservatism or otherwise, I don't know. But I think the patent system and then the IP system in general evolves very slowly. It's obviously strongly international, and the wheels of international agreement sort of by the nature turn slowly. But innovation and developments in this field are happening very fast. So I think there's a tension there.
Thank you very much. Peter asked me to take over because now we come to the two non-lawyers, and my observation is that the discussion is mainly led by lawyers, and that's why I'm so happy that we had two non-lawyers as speakers tonight, and that's exactly why I would like to hand over the questions to both of them and ask them, are you happy with the answer you just heard from the lawyers? And what's the role of the non-lawyers to provide information on this topic in order that those that decide in the end and that the politicians have an empirical base that is not only based on legal literature? Let's start with Avi.
Well, thanks a lot. Maybe I'll pick up one thread. I do think that we can get valuable intellectual property out of AI today. I am not sure whether it needs to be protected or not. I would argue that I do not know the answer to that question. And Gaetan, I hope you don't mind me saying, I think your thoughts are very well structured, but I would argue the jury is out how it will play out in practice, and whether there are loopholes to the system and the setup that you presented. For me as a computer scientist, I'm coming at this from an engineering point of view. It's like, can I do this? And the answer is yes. I am coming at this and you saw this like on the last slide as I'm going to ask people what do you want with this, right? So this is kind of almost a user interaction question. Do you think this is providing value? What the AI produces, etc. These are more these behavioral studies that are being done. But I think what is needed, and I'm very glad that Gaëtan mentioned this, is a societal discussion as to what's good for society, and not necessarily only for the individuals and the inventors, because obviously they're always going to argue for as much protection as possible. Just to give one of the issues that the act that Gaëtan mentioned is that it also, I think, it shifted the kind of research being done at the university to research that's more patentable in some disciplines. So it may have had unintended side effects that's parts of science suddenly started shifting what they were doing. At least I heard somebody argue that it's unclear whether on the whole it was a good idea or not a good idea to actually have that act and change and shift the kind of research done. So am I happy with what I'm hearing? I don't know. I wouldn't want to put it on them to kind of be able to predict the future, look into the crystal ball and kind of predict the future as to what is the right thing on a societal level. I think that's a very, very difficult question to answer. And so, you know, being conservative might be one dominant strategy to deal in this case, namely, let's see what happens. Is better than breaking something that seems to be working so far. Personally, I think what we need to very look at is that if the cost of invention will change massively from a marginal cost situation, which is what we currently have. Every invention has a large cost, to a high fixed cost, low marginal cost situation. So I have a high fixed cost to get the machinery in place, but then very low marginal cost of actually producing lots of invention, because that is what has happened in the field, in almost every field where computers have become predominant, right? We've changed from marginal cost to high fixed cost, low marginal cost field. What will that do to the invention machinery? And I think that is something that would worry me. And yes, we can counter patent flooding with more AI to, to get the differentiation between what good and what bad inventions are. But this fundamental change from a marginal cost to a fixed cost world, that is something that differentiates this fourth industrial revolutions to the second, the first, and the third, that we are really changing in that marginal versus fixed cost equation. It has changed the music industry massively. It has changed the movie industry, so the whole entertainment industry in terms of how we buy entertainment these days. It's likely to change all kinds of other industries. So I think we are looking at a different beast now. Maybe that's just a computer scientist looking at himself and thinking he is different than the others. But I do think this marginal versus fixed cost argument, I know I sound like an economist now, is pointing at a significant change in what we're looking at. Gaëtan, I don't know how you feel about this.
Yeah, I think that's an excellent point, and in fact, I'd like to build on that. And indeed, the patent system hasn't changed so much since the Venice patent law of the 15th century, I think, right? I may dare to say, perhaps because lawyers were in charge and were conservative. And so, yes, we've navigated centuries without changes, and we have passed successfully through a couple of industrial revolutions. But maybe the effect is the other way around. Having said that, I do believe indeed that this change in the cost of producing invention is actually truly different indeed from the other industrial revolution, and require other people, not only economists, but perhaps sociologists or ethics, or you name it, to look at the question of whether we should think of a different type of IP rights. It doesn't mean, it could be, and I agree, as soon as we introduce a new IP regimes, then we need to think of, okay, what are the consequences? How can we differentiate an AI generated inventions from a human inventions if the inventor doesn't disclose? So if the inventor lies, so what are the implications and how we can think of that? And of course, there are lots of issues to think about, and we'll make at least economists busy for a couple of years, publishing very advanced and hard to decrypt theoretical papers on what is the optimal strength, breadth, length, whatever of IP rights. But I do believe that we need really to think hard on the social implications of the social costs and benefits of having a type of IP protection for AI generated innovation. I think we cannot simply rely on let's do as we did before, and let's try and hope we'll navigate through this fourth industrial revolution. I think we need to take a broader perspective, but of course, I'm speaking for my church, if I may say.
Wow, what an afternoon. I think we have seen that the topic was so rich and broad that we ended up having less time for discussion than we would have wished to, but nonetheless, I think we should call it a day. I think all our minds are full with new thoughts and controversial issues. Sorry for having struck that conservatism chord. I think it will haunt me a bit, but maybe it has also in the Q&A brought up yet another range of topics that we will have to address in our June workshop, hopefully with all our speakers today together. For example, one further point that I think would deserve much more discussion is the data question, right? So how do data is so core, and how do you treat those data in applications, for example? We all know how much discussion is going on around claims for access to data and confidentiality protection regarding data, and competition law and contract law and all these aspects involved, and data protection laws and stuff. And at the same time, we would wish to have insight into the data when it comes to IP protection for AI systems. So this is also, a point Heli in particular touched upon in the patent section, but we would need to discuss that further. So I would like to conclude now. I can only thank the entire audience for the patience and also the good questions in the chat. I'm sure speakers will respond to them via email or maybe in the bilateral talks. Many thanks to our great speakers. That was really a bunch of great aspects and thoughts and experience from all over the world you brought to the table. Thanks again to IPI for hosting this together with us today. And I can only say that it was a fabulous afternoon, and that I'm very much looking forward to the continuation of this in June. And until then, stay safe, stay well, stay healthy, and think further about AI and IP. Bye-bye.